Hello, climbers, and welcome to Season 3 of Climbing Mount CMMC.
Hello, climbers, and welcome back. Today, we're joined with a special guest, Bailey Reichelt. Bailey, thank you so much for joining us.
Glad to be here, Bobby. We're going to talk about some of my favorite topics, export controls. So that's always exciting.
Yeah. Now, for you climbers that are just tuning in, we're going to be talking about export control data. We're going to be talking about CUI and export control and how this challenge really starts to come in. But I ran into you at CS2. You presented, but we never met. So it's kind of like this is really our first time really talking. And I just want to say you knocked it out of the park. You did such a great job. We're going to link the video that Bailey did in the description. And Kaylee, if you could somehow magically appear it somewhere around here, I'm not sure. You've got to check it out. We're going to talk about some general things around export controls. You know, we have a limited amount of time. Bailey's presentation was like an hour, I think, right? Isn't that what it was? So it was excellent. You definitely need to check it out. Also, you should check out Ryan's video that he did as well at CS2 on CUI and the marking of CUI, knowing it. That was a really good presentation. So we'll try to make sure we have that in the details. Those are really, I would say, two required videos that you need to watch. Those are really, really, really good. So Bailey, I just want to kind of dive in first to export control. What are some things that you feel like anyone that is in the defense industrial space, what do they need to know about export control first? What are some areas that you think they need to start to wrap their head around?
First of all, export controls has nothing to do with CUI. Export controls existed prior to the entire CUI program. In fact, they've been around a very, very long time. We actually, when I teach export controls, there's a cartoon. The first embargo was back during the revolution of the United States. So they've been around a while. There's nothing new about them. If you're a U.S. company or a U.S. person, you're subject to U.S. export controls. So if you're just learning about this now and you've been focused on CUI, just wanted to let you know there's a whole other body of law out there that governs and protects U.S. information and hardware when it's dealing with foreign persons. It'd probably be useful to tell you just the basic definition of an export. I'm going to start with the normal one everyone thinks about, and then we'll talk about the one that trips people up. So the first, most obvious definition of an export is when you take the item you're making, we'll call it a widget. You take that widget, you make it in the US, and you move it over to Europe. You've exported it outside of the United States. But that one's pretty easy to monitor because you know if you have a shipping department and that shipping department is having to fill out export forms in order for the thing to go on the boat or the airplane. The less common way people think about it is information. Every time you send an email, say that email has a drawing, a controlled drawing attached to it, some sort of technical information, and you send it to a parent company over in France, you've exported that drawing, even though it was just a digital transfer. Mm-hmm. Or, for instance, let's say your French counterparts, they come to visit your manufacturing facility in the US, and they walk around and they can observe that drawing because you left it on the printer. You can have a release of technology, and that's still a type of export. So there's a lot of ways you can export, even if you're not even thinking about interacting with a foreign country.
Yeah, those can be, I think, sneaky sometimes when you're not thinking about, you just want to operate as a business, you want to do your job, and you're not. What are some pitfalls that organizations can fall into about export control and misconceptions around that? Can you kind of maybe share some scenarios that would make sense to those types of organizations? So they're like, oh, okay, wait a minute. Now she's talking my language here. Can you kind of share some of that?
All right. Well, let me start with this first example. This comes up quite a bit. A lot of people, they've heard of EAR 99. So what is EAR 99? Well, when you're looking for the classification of your item and to know if something's controlled, you have to look for that thing or that information about that thing on these two lists. So the first list is the International Traffic in Arms Regulations, the ITAR, and the State Department is in charge of administering the ITAR's United States Munitions List. That's the name of the list. And then that's not that many things. It's mostly things that have military or weapons applications. A lot of things, most things, are over on the Export Administration Regulations Commerce Control List, which is governed by the Department of Commerce's Bureau of Industry and Security. So when you get over to the EAR's CCL, if you don't find the thing listed on the CCL, it's EAR 99. And what that means is whatever it is, that widget, it's still subject to the regulations in the EAR, but it might be eligible to ship without an authorization or a license. A lot of people, they have a strong misconception that if it's EAR 99, that none of the export rules apply. And that's not true. We still have a whole bunch of things like sanctions, or we have end-use controls. You still can't take, and the example I used from CS2 that seemed to be memorable to everyone is if you have a house cat and you want to ship your house cat, this time I'm going to go with like Germany. Let's say we're going to ship a house cat to Germany. It's a very special house cat. It's EAR 99. You're not going to find it listed on the Commerce Control List or the USML. So you take that house cat, you want to ship it, but the person in Germany who wants to receive it is on a restricted end user list of some sort that the government maintains. You are still not allowed to do business with certain persons. You're not allowed to send certain classifications of items to everywhere. So for instance, you can't send anything to North Korea. I think most people are familiar with that one. There's a lot of more nuanced controls. So if something is EAR 99, it does not mean you can do whatever you want with it or you're out from under export controls. And where this becomes particularly important to CUI is a lot of people look at the definitions of CUI and they make an argument, well, the thing has to be on the list. If it's EAR 99, not controlled. That's still not true. It's still subject to the EAR. So that's a bit of a nuance in the definition there. I do think there are arguments both ways, but just because it doesn't require a license does not mean it's out from under export controls.
Mm. And I love the fact that you talked about that it doesn't have to be a product, right? Something physical, like a technology device, or, it could be a bottle, or, intellectual knowledge, documents, emails, materials, right? Can you maybe walk me through some pitfalls organizations fall into when it comes to that? Because they might think to themselves, oh, I'm not shipping anything outside the United States, so therefore I don't have to worry about it. We're just business as usual for us, Bobby. Bailey, can you kind of walk us through about some pitfalls there where they run into, especially around the data that they have that they might leave the country with for whatever reason?
Sure. I think, Bobby, what you're hitting on is we call it a hand carry.
Mm-hmm.
And if you don't authorize it properly, it's called smuggling. A lot of people forget that term exists. So if you take your company laptop full of all their intellectual property, which let's assume it's export controlled in this situation, it's on a laptop. So just because you can't see it doesn't mean you didn't export it when you took it on a trip with you out of the country. That would still be an export, even though it's intangible. You still might need an authorization for it. You're still going to have to potentially declare things through customs, like that laptop, for instance. So just because you find laptops innocuous, it doesn't necessarily mean they won't be controlled. Most of them don't require a whole lot, but if it's super special, it has a lot of high-powered software, it's scientific, you still have to think about anything you're taking outside of the country. And encryption is kind of its own beast, but depending on levels of encryption, you might qualify for exceptions, you might have to declare it. There are some import restrictions on certain types of encryption, depending on where you're going. So
there's some areas where sorry, I didn't mean to step on you. Well, I was stepping on you. I apologize. Keep going. I want to hear everything you got to say.
Yeah. Just my final point was that if you're taking something outside of the country, whatever it is, it's still an export, whether or not it requires a license. So what is an export and whether it requires an authorization are two different questions.
Right. And we're definitely going to dive into, if you start running into these types of questions as you're coming through more, as we start to talk, your mind kind of might go, maybe I might need to talk to Bailey. Like, we're going to talk about what the type of an engagement with an export control attorney looks like. Bailey's really going to dive into that more. So I'm super excited to hear about that. But sometimes what people do, Bailey, is they'll wipe their laptop so there's nothing on it. They'll go to the other country and then reconnect and reprovision it encrypted style to that data so they can work temporarily out of the country. What are some pitfalls around that approach that sometimes people can get into?
Well, there are definitely ways to do that. And there are exceptions under both the ITAR and the EAR, which would allow a U.S. person to go travel and work remotely. The thing you have to think about is your secured environment. I find that that's the biggest issue, and you need to perhaps talk to your compliance officer about which country it is exactly. Mm-hmm. So while there may not be restrictions, or you can use an exception pretty openly, for most countries, you may run into some issues with China, for instance. Mm-hmm. So if you're working remotely from China, you probably want to have that conversation before you go. This is where most companies have a best practice of a travel authorization. And that's the part where they would wipe and certify that the laptop is clean, or they would get you an authorization for the type of information you might need to take with you and share while you're overseas. So most companies do have a process.
The authorization you're referring to, are they government authorizations, business, like the organization authorizations, maybe both? Like, can you speak a little bit more about the authorizations that you're referring to?
I'm going to talk about the government authorizations first.
Okay.
So there are a couple of different types of authorizations. And if you've ever dealt with the ITAR, you know that you have things like called defense services. You might have an agreement in place. You might have a license. You can also use exemptions from getting a license. All of these things are different types of authorizations. Some of them require that you interact with the government. Sometimes they're self-authorizations. The EAR has both licenses. They don't have agreements. They have licenses and they have exceptions. Exceptions often are self-authorized by the user. You don't have to give the government anything. Now, of course, you have to read the terms of the exceptions. Some require you interact or get approval for the government to use it. Some require you have at least one license approved by the government before you use an exception. But when I say authorization, I am talking about both government authorization and your ability to self-authorize based on the regulations. Mm-hmm. As far as companies, kind of your second topic there, whatever they choose to have as their internal policy, that runs the gamut on if they require certain authorizations, or they just want to make you watch a training video and you check a box saying, I watched the training and I am in compliance. And that's up to you. There's actually no real consistent standard. A lot of companies have a form-based solution where a compliance officer or legal reviews it and approves it, but none of these are regulatory requirements. They're about what works for your company.
Well, and it sounds like, as I hope people that are listening, like there are some rocky shoals and some things that you could step into here if you're not paying attention that could cause some potential risk for your organization. Me personally, I like dealing with experts to make me feel good at night to sleep. So around these types of challenges, it seems like we've kind of covered some things that should make people perk up to want to reach out to someone like yourself to try to determine where they are in that scope. Can you walk me through like what it would look like for someone to engage to you, and then what are the things that you would help them through that process? Does that make sense?
Absolutely. This is actually a pretty fun question. Mm-hmm. All right. What does it look like to engage a regulatory attorney or trade compliance attorney? Well, let's start with your Google search. You're looking to find the right person. As with anything, you should always interview a couple of people, because while the regulatory expertise might be the same across the board, it's probably not, but let's assume it is. You are going to want to find the person who works best with you. If you have really urgent timelines and needs, you want to look at how their communication style, how frequently they can communicate with you. So for my firm in particular, we have a minimum response time that we at least acknowledge that you've contacted us in the first day, and we try to get back to you to schedule a meeting within 2 business days. Often our response time is much faster than that. But you want to interview a couple of people. It doesn't have to be an attorney, by the way. So a lot of people like the attorney-client privilege, which comes with interacting with a law firm. And if you have a violation, that's certainly something to think about, because whatever you share with them, that attorney can now argue as privileged information should you come under investigation. You can, if you're looking for like classification assistance, you just want to make sure that your thing really is EAR 99, really doesn't require a license. You have some special scenario you need to figure out, and it's not sensitive in a litigation sense. There are plenty of consultants who do this type of work and do it very well, and they're often more affordable than going to law firms. So depending on the nature of what you need and the urgency and the sensitivity of that data, you would maybe let that guide your search. Maybe talk to attorneys, also talk to consultants. I want to say I'm going to give you a very ballpark estimate of what this might cost, because it always irritates me when people ask how to engage, but they never get to the money, because
Right.
that's a big factor. That's like a real factor, right? We need to know how much this costs.
Right. Yeah.
So my hourly rate is $500 an hour. I think I'm somewhere in the middle of the road.
Yeah.
My rate's intentionally kept here because I want to serve a market of small and startup businesses in the space sector. If you go to bigger firms in DC, you deal with their senior partners, I think you're going to get more of the $1,000 an hour rate. You can find plenty of consultants, probably in the, you can go with like the 300 to 800 range. They run the gamut of experience as well. There are some people I've been working with for a very long time. They've been in this industry for 20 plus years. They're around 400 or 500 an hour as well. So I think that's what you can
Yeah.
reasonably expect.
I think that's pretty reasonable, given the fact that if you could, like, say, for example, that you know that you're going to be communicating with a foreign entity about stuff, and you're like, I'm a little concerned here. I need to know where these guide rails are. Having someone like yourself on their Rolodex to spend a few hours of time just to start to understand what those potential risks are. And I mean, in those types of situations, how difficult is it for them to engage you to have at least an idea of whether they need to continue the conversation?
Only answer that with regard to me. I don't think
Right.
it's particularly difficult to engage me.
Right.
What we would just simply put an engagement agreement in place. We have a very small retainer for new clients of $2,000 that, of course, we draft against. We have a lot of different billing methods. So we do hourly, we do fixed fee retainers. For that scenario, Bobby, that you were mentioning, where you don't really know what you need and things come up and you just need someone to call without negotiating a contract each time. So we do things like that. Certainly, if you're looking for someone to help you, you can ask for things like that. A lot of law firms are willing, and a lot of consultants are willing to come up with alternate billing models to suit the client needs.
Yeah, I just feel like this is an area that a lot of times people just ignore and don't really pay attention to because they just want to operate. And like, I think that's very reasonable to try to get those answers. And then you can build policies around those types of things. Are those things like in more complicated situations that like, say, for example, that they are exporting and there is some serious shoals they might need to guide. For someone like yourself, are you able to engage on their behalf and actually contact the government and start kind of knocking some of those roadblocks out for them? Like, where can you guys step into that space and really help them?
I often contact the government on behalf of clients or even with clients on the phone with me. We have preemptive conversations about things they're trying to do. We try to understand if it's worth our time to ask permission. Not saying that we're not going to ask permission, but sometimes the answer is going to be no. And we need to brainstorm, okay, is this a no to your line of business, or do we need to change transaction details? We brainstorm solutions. We try to be creative within the bounds of the law. And a lot of times that does mean talking to the government preemptively to understand where their stance is going to be on something so that we don't waste time and money.
Yeah, that could be really instrumental. So you guys will even work in the policies on their side to help them with adjusting what they might need to do so that they're able to stay within the boundaries and operate safely.
Yes. one thing I want to clarify, a lot of people think if you hire a law firm that they can somehow change the rules. I want to go ahead and debunk that myth. I cannot change the rules for you, but I can help you navigate them thoughtfully.
Right. Right. Yeah, absolutely. And being able to make sure that you're doing it in a way that you're limiting your risk, right? I mean, that is super scary. As a managed service provider, we're providing support to our clients. We're helping them on their CMMC journey. There's risk we're inheriting. It literally in our agreement in the scoping guide, it says we have to accept the flow down of that data. So risk is a big deal with organizations. And then I just feel like having someone like you on their Rolodex just makes a lot of sense, being able to navigate those waters and help mitigate those risks and feel a lot better. Can you maybe walk to me through some of the partnerships and situations that you've helped guide people through? I know that you'd mentioned sometimes you work with Ryan at DefCert. Can you maybe share some stories about engagements and things that and how that goes?
Yeah. So I definitely worked with Ryan over at DevCert. I'm guessing that since we're not using last names, your listening audience will probably know who he is. Uh, so shout out to you, Ryan, and thank
Ryan
you
Bonner,
for
in case, yeah, for full disclosure.
shout out to you for working with us. We appreciate your patience. Ryan's really great at what he does. But yeah, sometimes we have clients who they're mid-level supply chain, for instance, or they're not the prime, in other words, and they'll receive overmarkings from the prime because the prime would rather just not deal with the CUI and export markings as granularly as they should. So they continue the trend of government overmarking, overmark again, and then flow it down. It's they're not going through and parsing out exactly if they can decontrol things and if the flow downs are necessarily required. So one of the things Ryan and I have talked about recently is about if you have a whole series of part numbers and you're sending those part numbers out to be manufactured by machine shops. Well, a long problem for big manufacturers and the rollout of all the cybersecurity regulations, CMMC or NIST 800-171, is that machine shops barely have antivirus half the time. And I know this because I had a machine shop with no antivirus shut down all the servers in a large aerospace company I worked for 2 days once, just because they gave us a USB with a virus on it. So there's liability, but also we can't completely restructure our supply chains around the two-person machine shop down the road. It's going to really throw a kink in our business and our lead times. With lead times could come contractual penalties. It's a snowballing issue. So it's worth taking the time to really figure out who you need to constrain and apply these requirements to and flow them down to. So one of the things we were looking at is part numbers, because we have seen some companies say that part numbers are export controlled and are also a type of CUI. We're like, oh, interesting. So if you're basing that on export controls, well, first of all, we need to see if it's actually export controlled. I'm just going
Right.
to
Yeah.
tell you, part numbers are not export controlled. They're not EAR 99. They're not subject to the EAR. Why is that? They don't meet the definition of technology. There is a specific definition. They're not that. They're not subject to the EAR. They're in the public domain. Anyway, part numbers are not subject to the EAR. What I'm saying is literally that string of digits that is the number, right? I'm not talking about what drawing it corresponds to. I'm talking about the string of digits. And so if you have a machine shop and you need to give them just that string of digits, do you necessarily need to flow down all the CUI safeguarding provisions? Do you need to flow down any export control provisions?
Well,
So
in
that's a good
situations like
question.
that, if you're able to do that cost effectively, now when you're pulling in your subs, they probably should be and could be less expensive because they don't have those requirements you're flowing down, right? So
Absolutely.
spending the time and money to engage someone like yourselves to help define and have a process to decontrol those as you share those out and do it with confidence could really ultimately make your upstream bids much cheaper and you have better opportunities for business. There's a lot of potential there.
Certainly what we're hoping to capture for our clients. It is tedious. Not everyone has the appetite to do that level of tedious decontrol. But for small businesses, it can really be a game changer. It really gives them what they need to make the argument to push back up the chain. And like you said, Bobby, makes them more competitive because they're not having to increase cost through their supply chains. It's really hard to quantify all of this, but we do hope to see when we do this with clients that, a year later, that they do have savings and they do have less bureaucracy they're having to manage down the supply chain. So one thing I didn't answer completely that we could go back to is if you engage with an expert, what is it exactly they would do? One of the things you should expect to have if you have export control data and you engage with external counsel, well, first of all, you should expect that if you're asking them to apply for licenses or things, it should not become a completely hands-off process. You're not outsourcing your compliance. You can do that. There are people that will allow you to do that. It's a great business model for them because you're stuck with them forever now because all the government correspondence is running through them. They submit the license for you. You don't own your own data. I mean, there's some problems with that inherently from a risk perspective. I don't operate like that. I don't want to operate like that. I want you to own control of your data, your risk, your compliance. So what I want you to do is learn how to do what I'm doing to some degree. Like, I'm not going to teach you to be a lawyer. I always want to be there to help you guide the hard, complicated questions. And there are plenty of those because the regs are fraught with inconsistent usage of words and inconsistent application. But ultimately, you should be aware enough that when someone walks by your office, if you're in charge of compliance or any of that at all, they could stop and have a meaningful conversation about the risk, and you could gauge it internally. This looks like building a compliance program. It's establishing workflows and procedures that help you check all the boxes of what the government expects in a functional export compliance program. And you can combine this in many ways. It doesn't have to be a dusty book on one person's desk. I actually prefer you don't do that. No one's going to ever read that book. You should look at ways you can automate and integrate compliance into your systems. You still need written procedures. Don't operate on tribal wisdom. I don't know how many times I'll have to say don't operate on tribal wisdom, but if you're listening to this, you already know through building your cybersecurity procedures that you need to write things down. You could, and I like to say, win the lottery instead of hit the bus or get hit by the bus now. But you win the lottery. Someone else comes in to take your job when you peace out 24 hours later. They need to know what's happening, where things are. You're hiring a new employee the next day. They need to know how to train them. So write it down. Don't rely on tribal wisdom. You can combine your export compliance into other workflows. So also don't get stuck in the trap of thinking that export compliance has to be all by itself. I've seen companies build export compliance controls into ISO procedures. That's if you take it real serious because you're going to get audited against it, right?
Right.
So you can do that. You can combine cybersecurity and exports anywhere that you have existing workflows. For instance, when you're processing vendors to add them into your whatever system you use to pay them, you could build in due diligence screenings at that portion that your CFO approves. When you do your contract reviews, you have everyone in a room. They're doing a big kickoff meeting for a big government program. You want compliance or legal in the room and signing off if there's any international aspects of this that you might need to consider export controls. So don't think you have to go create a whole program. Take your existing workflows, take inventory of them, and then add in the compliance pieces to it so that people actually use it.
Well, with CMMC, it's going to require a system security plan, a lot more policies and procedures. Do you see that also somehow being leveraged as part of that process and having procedures that could be in those systems?
Let me give you an example of where the very first time I combined cybersecurity procedures and export procedures was actually in marking and storage requirements. We do have safeguarding requirements under the export regs. They're not as high, but we still want to make sure there's no unauthorized access. We also want to make sure things are marked correctly, because if things aren't marked correctly, they won't be stored correctly. And we were able to combine in those areas and give companies kind of a matrix on the different types of markings. And you can go further and also get to confidential and proprietary, right? So you can pull it all together in one procedure. This is our list of all markings, and this is how we apply them to documents. And if it's not a government contract or generated for a government contract with the appropriate CUI flowdowns, well, we're not going to be applying the CUI marking, but we might still need an export control marking or proprietary or confidential.
Yeah, those are all still relevant. I mean, because export control isn't necessarily CUI and vice versa, right? So, I mean, you've got to really understand the differences between the twos, and having those in procedure definitely helps get that thinking through. And like you said, if that one person wins the lottery and that's the only person in your organization that understands that, then you just lost an important person that helps keep you out of the trouble.
Absolutely.
Well, Bailey, thank you so much for joining us. You really touched on some stuff that I think is got some mysticism, some misunderstanding, some tribal knowledge, some, storytelling, and it just creates a lot of misunderstanding. I think you helped provide some more clarity. Thank you, Bailey, so much for helping us.
I'm glad I could be here. If I could leave your listening audience with one piece of wisdom, it's if you were listening to this and you suddenly felt overwhelmed and like you're going to go to jail. Well, first of all, you're probably not going to go to jail. I guess it depends on what you did, but probably not. But two, if you don't know where to start, then just take it a step at a time, just like you've been doing with cybersecurity. No one expects you to have everything 100% tomorrow. This is a journey that you'll be on for the life of your company or your career. The regs are always changing. The standards are always changing. And this is a process. It's not a destination.
Well, Bailey, in those type situations, having someone like yourself in their Rolodex, like how can they find you if they want to talk to you about these types of challenges?
You can find me on LinkedIn. Just search my name, Bailey Reichelt. You can look up Aegis Space Law, AEGIS. I think we're the only space law firm, so it's pretty easy so far. I think eventually there'll be some more space law firms, but we're the only one
I
out
love
there.
your logo. It's got the astronaut guy. That's really cool. I love that logo.
Yeah, and the shield. The shield's the Greek Aegis, if you were wondering what that had to do with the astronaut.
Okay. All right. Now I know. Well, it's been great. We've been kind of corresponding back and forth trying to get you on the show. You're so busy. You guys are taking off, and so glad to see, someone like yourself stepping into industry, really helping provide a valued service, trying to provide clarity and limit risk. So definitely check out Bailey's on LinkedIn. Look at the video that we have. She has some great information. If she's ever speaking, definitely check out her sessions. You're going to learn a ton. I learned a lot from just having her on the podcast. So thank you so much again, Bailey. And climbers, we appreciate you joining us today. And as always, keep on climbing.
Make sure to follow us on LinkedIn and YouTube to stay up to date on the latest CMMC news. We hope you guys enjoyed today's episode and listen out for the next one. But until then, keep on climbing.